Welcome to Heather Sells NYC with your host, Heather M. Cooper. Each episode is focused on helping people navigate through the intricacies of buying and selling real estate in New York City to get the greatest value. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcasts, Spotify, and on our website, heathersellsnyc.com. Now here's the host of Heather Sells NYC, Heather M. Cooper.
Good morning. Hello. How are you, Larry? And thank you for being on the show.
Thank you for having me. Good morning.
Good morning. So today I wanted to introduce my real estate attorney extraordinaire, Larry Chaifetz, from the law firm of Chaifetz and Chaifetz. Larry has over 30 years of experience in real estate with offices in Manhattan and practices real estate all over the state of New York. Thank you so much for coming on today. Really appreciate it.
My pleasure. My pleasure.
So Larry, tell me a little bit about how did you get started in real estate, and how did Chaifetz and Chaifetz come about?
Well, let's see. I got started in real estate by being exposed to real estate through my initially working with my father, who I was in practice with for over 30 years, and his practice at that time when I started working with him had a lot of real estate work that was involved in different types of real estate. And that's really how I got my feet wet in learning about real estate and handling closings and people who purchase properties, sell properties, or have disputes about real estate. My background is in college, I was in business school. So I have a good business background. And then in law school, I somewhat concentrated in business related activities and real estate, and somehow gravitated towards real estate because it does have a lot of the components of business in it, which is very attractive to me. And I think that makes real estate that much more exciting because of the nature of every deal is a different transaction and has a unique aspect to it, and involves a lot of the components of business intricacies that keep things exciting and keeps your mind going as to how to work that particular transaction to the best of your abilities and representing a client in the best way you can possibly do.
Absolutely. There is definitely no 2 days and no two deals that are the same in real estate, and no two clients that are the same.
I agree. Yeah, I agree. And that's really, for me, that's what keeps things exciting. If it was every deal was the same, things wouldn't be as exciting and exhilarating in the way that it is, because as you had mentioned, every deal is different. Every client has a different sensitivity to a particular issue in a transaction, and every purchase and every apartment is different, which really makes you, as the attorney for the purchaser or the seller, have to focus on those specific aspects and make sure that your client's rights are protected, and you've given the clients the information that they need to understand what the benefits are and what the detriments are. And there's no two deals that are the same, which really, I think, is a testament to the benefits of being a real estate attorney. And things have definitely evolved in the last 30 years in a good way, I think, especially much differently because of COVID, which again has evolved again. The real estate practice has evolved further because of COVID. And again, that just again keeps things fresh and keeps you updated as to how these processes work, and helps you in making these transactions as smooth as possible for your clients.
Yeah, thank you. Thank you so much for this elaborate explanation, because you certainly have to flip your brain a lot when representing a buyer and when representing a seller. I mean, especially flip your brain even more when it's a co-op or when it's a condo. And then there's different nuances also to boot. If there's a guarantor, or if somebody is co-purchasing, I guess why don't we touch on, because some of the viewers here might not understand, when purchasing, why would we why would a buyer want to use a co-purchaser, or what's the difference between a co-purchaser and a guarantor?
Okay. Good, really good question, and there's a lot of nuances to it. So, for a co-purchaser, that means that two individuals, or maybe more than two individuals, will own a particular apartment. If it's a co-op, they would be co-owners of the shares of stock. If it's a condo, there would be some sort of co-ownership on the deed. With a condo, those percentages can be divided. So if you had two people, it doesn't necessarily have to be 50%, 50%. It can be divided up in different percentages. And for some co-ops, depending on the nature of that particular co-op, they also can be divided in proportions that the parties want. It doesn't necessarily have to be 50-50. So that's potentially a co-purchasing situation, where the individuals each own the apartment. And the difference, where there is a guarantor, the guarantor is not an owner. So they don't get the benefits or the detriments of being an owner of an apartment, but the guarantor is guaranteeing usually the payment of the either maintenance for a co-op or common charge for a condominium. So there's a big difference in that, because as a co-purchaser, you're a co-owner and you get the benefits and detriments of being a co-owner, meaning that you can live in that apartment, but also you're responsible for all of the fees and charges that accrue as a result of your owning that apartment. And the difference with a guarantor, you're not an owner. All you are doing is just guaranteeing the payment of the common charge or the maintenance. And also, you're also, in most instances, guaranteeing that the owner of the apartment will abide by all the rules and regulations of either the co-op or the condo. So that's really the big difference. One of the other things to touch on in this scenario is how somebody holds title. So there are different ways to hold title. And if parties, let's say, are co-owners and they are legally married, then automatically they have what's called the rights of survivorship, meaning that if, God forbid, one of the co-owners passes away, by operation of law, the survivor of that co-ownership would own the apartment by operation of law without having to do anything through the courts or anything else. The other option is what's called tenants in common, where each party owns their interest, and that interest stays with them for their length of ownership of the property. So if, God forbid, one of those co-owners passes away, then the interest that they own as a tenants in common will go to the party that passes away, and the other interest would remain with the party that survives. So again, people decide for different reasons and different nuances whether they want what's called rights of survivorship, or whether they want what's called tenants in common. And again, there are some nuances. There's some tax reasons why people they hold title in different ways. But again, these are different options that you'll discuss with your attorney at the time when you're purchasing your apartment as to what is the best way to hold title for your particular needs and purposes.
Got it. And just out of curiosity, some co-op boards do not allow for co-purchasing or for guarantors.
Correct.
From your point of view, is there a reason why a co-op would not like this type of structure?
Sure, sure. Well, yeah, so understand every co-op and condo, as we discussed before, has its own nuance. There's no co-op or condo that's the same.
Right,
Which
absolutely.
again keeps things fresh for all of us. So every co-op has their little nuance as to how they operate and what they allow in their buildings. But generally, I think the feeling for buildings is that if you have a co-purchaser, let's just say, let's use instead of a co-purchaser being a husband and wife, but let's say a child and a parent. Some co-ops do not want there to be co-purchasing because technically then there's an additional individual who's allowed to reside in the apartment because being a co-owner, as I said before, gives you the benefits and the detriments of owning that apartment. And because you're a co-owner, you get all the rights of being an owner, meaning you have the additional rights of living there. So so some co-ops believe that if a parent is purchasing an apartment with a child or purchasing an apartment for a child, and they have no intention of living there, they don't feel comfortable having the parent also being a co-owner and owning the shares or being on the deed because of the fact that they technically aren't really going to be living there. So they just don't feel that it meets the proper qualifications of the building to do that. Conversely, some buildings don't like guarantors. They would rather the parties have a co-ownership process as opposed to a guarantor because they feel, again, on the guarantor side, they they don't want an additional party guaranteeing the maintenance, even and not living there, and they would rather somebody be an owner, and as an owner, you're already obligated to pay the maintenance and abide by all the rules and regulations of the building. And again, these are just kind of nuances that every building has, and that I know in working with you in many transactions that these are the things that we as a team would investigate for a client to determine what the rules of that building are, and then advise the client accordingly what the best way to handle that is, that rule based upon what their priorities are.
Right, exactly. I mean, it's like, you're definitely doing a little bit of an excavation, so to speak, because, before the client puts in an offer and, say we have a buyer that wants to have a guarantor, and sometimes it's a little bit more challenging for someone like myself where the board or the managing agent says, oh, guarantors are case by case. So, and you have a client that's pushing for a guarantor. So it's certainly a risk. But if that's the only way that the client wants to structure the deal, then we have to take the chance
That's
if
correct.
the listing broker is open to it.
Correct. And unfortunately, that's kind of the nature of especially co-ops in the sense that everything is based upon the approval of the board and the approval of the application. And because of the fact that every application is different and every building has different nuances, we as the professionals that are guiding our clients have to give them the best opportunity to gain the approval of the board, and in doing that, we have to base that upon what previous transactions have done and what the buildings have allowed in the past, and you don't want to rework what may have to be done. So you want to try to stay consistent so that you give your client the best opportunity to get the approval of the board under that particular scenario.
Absolutely. Absolutely. Something just came to mind, and I was curious. In your 30 years, 30 plus years rather, what was your most interesting or most difficult real estate deal?
Let's see. So most interesting, I'd have to say probably the most interesting scenarios are really the ones that have a lot of different what we call kind of tentacles, where there it's not just a clean purchase and sale where everything goes smoothly, which is what you want. But I guess the ones that kind of stick in your mind are the ones where you hit all of these different roadblocks to get to the point of closing. And then ultimately, after having all those roadblocks, you are ultimately successful in getting the deal done. And there are some specific deals that I've worked on where, for whatever reason, there were issues with title, or there were some problems with the person's finances, and we had to rework the deal to make the building feel more comfortable about the transaction. And these kind of deals for me were they just had more energy had to be put towards them, but the accomplishment aspect was a little greater because of the fact you had to go through all of these different hoops to get to the final end of the transaction, which ultimately would be the client either selling or purchasing the apartment.
Right. That is the accomplishment, right?
Yes, absolutely.
In real estate, we want to get them to the finish line.
Correct.
And,
Correct. Yes.
That's the happy part of
Absolutely.
our
Yeah.
job.
I mean, I'm working on a transaction now, which is what's called a short sale transaction. And short sales traditionally can take many, many months and sometimes years. And basically, what a short sale is a transaction where the purchase price is less than the amount of the loan on the property. So what you have to do as part of this transaction is obtain the consent of the bank that's holding the loan on the property to allow them to receive less money than the mortgage that's owed on the property. And unfortunately, with these kind of transactions, it's not an individual who will make a decision and say, "Oh yes, we will only we will accept this less amount of money and do the transaction." It has to go through many different stages with depending on the bank to get the approvals, and part of that is the bank requires an appraisal of the value of the property, so they can determine whether the price that the buyer is going to pay is a fair price based upon market conditions. Sometimes they ask for an engineering report. Sometimes they ask for financials on the purchaser. So you can imagine that at each stage, the process can take a while. And then the bank from internally on the bank side, they go through different committees and reviews to determine what the best case scenario can be for them. So some of these deals, this particular deal I'm working on now has been going on for 2.5 years. And, it's still going strong, and we're hoping it's going to close. But at each stage, different things happen. And unfortunately, when properties are being sold like this, things happen to the properties. And in one property, there was a huge flood in the house. And so now that changed the whole dynamics of the deal, because now the property had to be repaired and the person didn't have the money to make the repair. And all of these different things get caught up in these kind of deals, because as you can imagine, as time goes on, different things can happen to these properties. So these are the kind of deals that, even though they're frustrating for all parties, ultimately, if you can accomplish getting them completed, it's very satisfying for all parties.
Right. Absolutely. I mean, the goal is, to make the clients happy and to get to the completion
Right.
of the deal.
Without a doubt.
Absolutely.
Yeah.
So, I have another question. I have a client that is considering buying a land lease. Now, the building that she's considering, the maintenance is higher, because of the land lease. And I guess we should just touch on, what is a land lease and why should buyers, what should buyers consider when purchasing a land lease? Is it not in a buyer's best interest to purchase a land lease, or does it depends on like?
Yeah, I mean, again, this is one of those unique situations in a real estate transaction. As we talked about before, every building has a unique aspect to it, and every transaction has a unique aspect to it. And one of those aspects, as you were referring to, is a building. Mostly, the issue is in a cooperative building, where the land that the building sits on is not owned by the building, which is the more traditional way that cooperative buildings are run. Is that the land underneath the building is owned by the cooperative corporation. So there's no issue with whether or not the property is owned or not owned by the co-op. In the scenario that you are referring to, the land is not owned by the building. So the land is owned by a separate entity, and the building rents the land from the owner of the land, and that presents unique issues for a purchaser. The unique issues are that now you need to determine what these terms of the land lease are, because that has a great effect on the viability of the co-op itself, the viability of your ownership of the apartment, and possibly the overhead expenses that the building has to incur. So, for example, let's just bring some of the apartments that are in Battery Park. So those apartments in Battery Park are all land lease buildings. They are owned by the city and the state of New York. And that land lease there specifically expires in 2069. Now, that seems like a long way away, but it's really not that long, because, as you know, in the ways that these deals are analyzed, a traditional loan is given by a bank for 30 years. So a bank wants to make sure that they have the ability to collect on their loan, and that the ownership of this apartment is going to be maintained for at least 30 years. So, for example, in those particular instances where the land lease expires in 2069, it becomes really important for a purchaser to understand that technically, if that land lease is not extended after the 2069, then that apartment and the apartment complex basically becomes valueless, because now the building has no right to remain on this property. Technically,
Right.
all of the apartments have no value anymore, and they technically would have to move out of their apartments with losing all the value in their apartment. So
Oh, wow.
that's a big risk that someone has to understand and realize, that these are the risks that could happen if, in fact, in this particular instance in Battery Park, these
Right.
land leases are not extended. In the particular instance, I think when you're talking about is not in Battery Park, where there's another building or buildings that are on the Upper East Side, which are again land lease buildings. And these are, I think, land leases that are owned by either an investment group or an individual family or an individual person. So again, the same concept. The land lease has a termination date,
Mm-hmm.
and that has to be investigated to determine how long of a length of time does the lease extend for. Because again, the concern for a buyer is if the land lease is coming due in the near future within the next 50 years, then that is a consideration because it has a direct effect on the value of the apartment. Because as you get closer to that termination date, technically the apartment is going to become less valuable because now the lease has less time. And technically, if the lease expires, and technically, as I said, if the lease expires and is not renewed, the interest of the parties will be extinguished, and that apartment will have no value. So again, with these land lease deals, our job as the attorney for the purchaser is to analyze the terms of the land lease, explain to the client what the benefits and the detriments are. In many instances, in land lease buildings, the market price is reflective of the risk that you're taking with a land lease. So if you're trying to compare apples to apples, if you were buying a one-bedroom apartment in a land lease building, as opposed to buying a one-bedroom apartment in a non-land lease building, the apartment in the land lease building would be much less expensive. And because you're getting a discount, because there are risks involved in a land lease building, and the market doesn't value a land lease building in the same way that they do with a non-land lease building. In general, if there's a land lease that is for a very long period of time, let's say 100 years, then that's what's called tantamount to full ownership. And there still may be some discount, but in most instances, a land lease that has that long of a term will be considered a building that does not have as big of a concern with the land lease, as opposed to a building that maybe has only 50 years left for the term itself.
Thank you. That's a good explanation. I mean, it's good because a lot of people think, oh, this is such a great deal, but it's good, my client, she's a 2-bedroom for about $650, whereas the market value would be about 1.8 in that area. So, because of the price, she wants to take the risk. But obviously, it's good I always tell my clients, listen, speak to an attorney so you really understand about the detriments and what an actual land lease is. Because I can tell them, but I want to actually gear them to you to learn and understand.
Yeah, and it's very important. Look, that's part of our job as professionals in helping clients understand what this means. We do this every day, so we somewhat sometimes forget that this is probably someone's first time investing or buying or making this their home, and you kind of have to back up a little and remember that this is the first time that they're being exposed to this, and they have to really, really understand the differences between a non-land lease building and a land lease building, and what the benefits are and what the detriments are, and the reasons why a price maybe is discounted for a land lease building, and maybe why the maintenance is higher proportionally in a land lease building as opposed to a non-land lease building. So again, our job is to educate. And as long as the client is fully understanding of what the aspects of the transaction is and what the benefits are, then we've done our job, and then they can make an educated decision whether this suits their priorities and in making this particular purchase.
Yeah, absolutely. It's so important to look out for the buyer and the seller when representing them. And speaking of the seller, on the flip side, what is it that you do differently? Obviously, we want to represent them and make sure that they're getting the best representation in terms of selling their property quickly and efficiently. What do you do for the sellers that's different than the buyers?
Oh, really good question. So on the seller side, obviously there's a different priority because they obviously want to sell their apartment. So, important things that I try to concentrate on in a sale contract, especially in a land lease building where a seller is selling an apartment in a land lease building, is disclosure, because you know you want to be as transparent in my mind as possible, because for both of us as the selling real estate broker or the attorney representing the seller, the last thing we want is after the deal's done for the buyer to come back and say, "Oh, I didn't know this. I didn't know that. Now I'm going to start a lawsuit because I was never advised that this was a land lease building, or that a window could be sealed up. I didn't understand that." So what I try to do in representing a seller is give full disclosure. So for example, if there is a land lease building that my client owns, I would specifically put in the contract that this apartment is subject to an underlying land lease, and refer to that information that may be in the cooperative offering plan or in the financials of the building. So again, that it's clear, it's there, it's something that is transparent, so that you're protecting the seller in the sense that now the buyer doesn't mean they can't come back and do something about it, but at least you've been transparent and they can't say that we didn't know about it, because it's in
Right.
a contract that they're going to sign. So they would have full disclosure as to what they're buying, and what the benefits again and detriments are to that particular transaction. Yeah.
Right, absolutely.
Yeah.
Now, we haven't touched on new developments. New
Mhm.
developments are, a lot of international buyers love new developments, and just a lot of buyers in general. What comes with a new development is sometimes you're buying on a floor plan. Sometimes, buyers are a year out from actually closing. And some people have asked me, well, what happens if they don't close? You put down like a 10% deposit, and then what happens if the developer fails, or what happens if the project gets stalled? What happens if if they're completed in 3 years instead of 1 year? Then what happens?
Sorry.
Always.
So again, again, in keeping things fresh for us as in this field, new developments have their own different nuance, and every new development project, depending on what phase it's in, presents its own unique issues. So generally, what we're talking about in new development projects are buildings that were either converted from a residential rental building to a condo or a cooperative, or a building that was specifically built as a condo or cooperative. So generally, in these buildings, why they are attractive to many different people, maybe sometimes foreign investors, is because technically everything is going to be new. All of the systems in the building are going to be new or renovated. All of the apartment, properties in the apartment are going to be new. So that obviously has a big attraction to potential investors or to individuals. And so that there's an attraction there. But the nuances to these things, especially if this is a building that was built specifically for as a condo or a co-op, is that it's new. Now, again, it's new means that you're getting a brand new dishwasher, and you're getting a brand new refrigerator. But then the nuance to these things in a building concept is that in many instances they've never been used. So it may be when you move into this building, they've never turned on the air conditioning system in the whole building yet because they haven't had to. So
Right.
sometimes these kind of kinks have to be worked out, and buyers have to understand that when they buy into these kind of new development projects, that even though it's new, you're going to have hiccups and kinks with some of the building systems. Again, it may be the first time that the heat has been turned on in the building because it's the first winter that the building has really been operating. And as much as these systems are supposed to work properly, they just until they get turned on and everyone turns on their system or their radiator or whatever heating system it is, no one knows how it's going to react. And again, there are a lot of hiccups with those things. You'll also in a new development, unfortunately, as part of the process, you are in many instances required to purchase your apartment before the building's completed. So
Mm-hmm.
I've had clients literally having to move into an apartment where the apartment is physically finished, but the hallways aren't finished. Okay. So
Right.
then they're walking through a building where the hallways aren't finished. Maybe the lobby's finished, but most likely the bike room's not finished. The media room's not finished. The playroom's not finished. The roof deck's not finished. The pool's not finished. And so now you're living in a building with why you're buying it, it's because of all potentially these amenities, but you may not have these amenities for a period of time. Sometimes it's years because the sponsor or the developer of these properties, depending on the state of these projects, want to get the apartments finished and get them sold, get them off of their rolls, and then the next step for them is to then work on the common areas.
Mm-hmm.
So sometimes, clients have to be made aware that that's a real risk. And
Right.
that's now assuming that the apartment and the building have been completed. One of the things you brought up before is sometimes people are buying in new developments when the building even hasn't even been put up yet. And they're buying it based upon a model. And they look at the model and they say, "Oh, that model looks great. I want an apartment like that." But physically, the building's not up, or even if the building's up, the apartment's not there. So you don't physically see the apartment, and that's taking a huge leap of faith in doing that. And then the bigger issue, as you said, is that the one of the nuances of New York City real estate and building is that things take a lot longer than they expect or they project,
Mm-hmm.
especially during times of COVID, and things are still catching up because of COVID. So as you had mentioned, there are projects where you could sign a contract now or a few years ago, and that project may not be completed for 2 or 3 years or more. And then, so now you, as the buyer, are sitting with an obligation to buy this apartment. In
Mm-hmm.
many instances, with these new construction deals, you're putting more than 10% down, sometimes 15, sometimes 20% down. So you're tying up a lot of money, and you now have to wait until this project gets completed. One of the things that we try to do when we represent purchasers in new development projects is we try to negotiate an outside date in which the purchaser can cancel the contract.
Mm-hmm.
Um, and that gives them some control over when, if the building or the apartment's not ready within a certain period of time, then they can cancel, get their down payment back, and be done with the transaction. And this gives the purchaser some control as to, knowing that worst case scenario, if within 9 months or a year or 6 months, whatever we negotiate, the deal's not done, then at least they can get their money back. But
Right.
depending on
How
market,
often?
right?
How sorry to interrupt. How
Sure.
how often is this done? Is this done in every deal, or does it depend upon how far out
It
the
depends.
project is
Yeah,
done?
every deal, as we said, is different, and it's
Sure.
a lot of it's dependent upon market conditions. It depends on how cooperative the sponsor and developer wants to be, and depends on the market, whether it's more of a seller's market, more of a buyer's market, and there's a nuance, and it depends on the time. You may be different than somebody if you signed a contract where the project just started 6 months ago, and then someone signed a contract 6 months later. That transaction may be different. So it's very hard to tell. There's no hard and fast rule. It's unique to each building and to the process and to how long they project for it to be completed or done. So it's based upon that particular building and that particular time that you're signing the contract.
Yeah.
And depending on when it is, we try to negotiate the best terms possible. But again, the clients are advised at that time that they may be stuck with this transaction for a long period of time if the developer will not agree to a termination date, or worst case scenario, if we can negotiate a termination date, then they at least know that worst case scenario, they can get out of the contract at that particular time.
Right, right. Yeah, I mean, I know in certain times, maybe in 2021, I had a deal with a buyer, and the developer sponsor was not negotiating anything. They threw in a storage unit. I mean, whereas last year, the developer, certainly we negotiated the price and um, a couple of other things where my client was quite happy. So it really just depends upon where they are with the project, how far along, how many units sold, and so forth, and whether it's a buyer or seller's market. So
Absolutely, yeah. There's so many, it's again with as you know, with every deal, it's unique to the particular time, to the particular the deal and transaction. You could have done a deal 3 months before with somebody else and negotiate a specific term. And now 3 months later, you have another client who's trying to buy an apartment in the same building, and you go back to the developer and say, well, hey, you allowed us to do X, Y, and Z then, and then they may come back and say, yeah, well, that was 3 months ago. The market was X, Y, and Z. Now the market's this way. This is all we're going to give you. So, it's a function of the timing, what's going on in the marketplace, and so many different factors that's why, I'm always happy that there are, when I'm working with you, of course, and because you are experienced, you understand the market, and that's the value to me of working with a good real estate broker, because you guys are on the ground and you understand what the market conditions are every day, and every day they're changing. And for me as the lawyer, I'm looking at the legal aspect of these things, and again, they're changing too depending on the particular deal and time. But you as the real estate broker are seeing how markets are affecting different terms, and that's the value that you give to a client in guiding them and letting them know whether they're getting the best price or they're getting the best concession from a particular seller or buyer in that particular instance. Because we as the attorneys, that's not kind of our bailiwick. We don't get involved in that. Those are business decisions that we really are not experienced in or have enough knowledge in to be able to advise our clients about those particular issues.
right, exactly, because a client could ask you, "Oh, do you think I'm getting a good deal?" And then you have to tell them, "Well, follow up with Heather, and then she can advise you on the comps in the building and
Right,
so forth, whether
right,
they're buying or selling. Obviously, it depends upon the timing, as we discussed.
right. And as you know, I mean, even though they're comps, this particular apartment may have some unique aspects, good or bad, right? So the comps may show the apartment should be this, but this apartment has a river view, or this apartment maybe has a terrace and the other apartments didn't, or this
Hmm.
apartment has, brand new appliances. That's where you come in, because you say, well, yeah, the apartment was the last comp show this, but here are some other things to take into effect. So we think that this is going to be valued differently. And that's the nuance that you bring to the aspect of advising clients, whether or not they are getting the best price or what price they should be marketing the apartment for. And that's where we always defer to the real estate broker and say, look, we can analyze all of the legal aspects and what's in writing and what's in the offering plans and what expenses you have. But from looking at the business side of the things, that's where we say, no, you need to speak to Heather because she's the one that can tell you what, whether X, Y, and Z is true or correct or undervalued or overvalued or whatever the situation may be.
Right, right. Yeah, because when speaking to a buyer or when speaking to a seller, I mean, it's really all about the motivation. I mean, when speaking to a buyer, we have to find out, what's the end goal and why are you buying? Are you buying because you need more space? Are you buying for your child? Are you buying because you want to hold it for 10, 20 years? I mean, it's really just asking questions and learning really about the client. And that's just so important.
Yeah, it's absolutely important, especially look, think about a seller who, if you, when you analyze why are they selling the apartment? Well, some sellers say, well, I need to get out. I have a financial, I'm purchasing another house, and I need to buy that immediately. Well, you then have to make a decision how you're going to price that apartment because now you know that timing is really important. So maybe you're going to be a little more aggressive in pricing that apartment so that they have a better chance of getting an offer quickly.
Right.
Whereas maybe a seller will come back to you and say, I don't have a rush. We're selling it. Whether it takes 2 months, 6 months, a year, it's really not that important to us. Well, again, from you may say, okay, well, then maybe you'll say that you'll be less aggressive on the price because they're not as concerned about, how quickly the deal is going to happen. So, these are things that you as the broker will analyze before the contract or the terms get to us, and we will either review the contract or prepare the contract based upon those issues.
Right. Absolutely. Absolutely. I mean, it's just really about working in our client's best interests. I think that's bottom line, and working as a team and making sure, I mean, by the time that they come to you, Larry, they have already, pretty much are going to give an offer, have an accepted offer. So they know that, okay, I am selling it, or they know that they want this particular apartment in this building, and they are confident of it. So your role is to make sure that they're making that best decision. And when working when working for my buyers, just in a, what are you looking for? I believe you look at the financials, you look at the offering plan, and you look at the co-op board minutes. What else are you
Yeah,
looking?
so that this in representing a buyer, what we offer to our clients when we agree to represent them is what we do is what's called the due diligence aspect of the building. And in doing that, as you had mentioned, what we'll first do is we will review the financials to the building, the latest financials. We will review hopefully the budgets to the building, because sometimes the latest financials, for example, now are for 2022. So that's the latest financials you may have, but then you want to see hopefully budgets for 2023 or 2024. We'll review the offering plan, or the black book people call it, which is the book that kind of presides over all of the operations of the building. We will also review all the amendments to the offering plan to make sure that there's nothing in these amendments that could have any great effect on the operations of the building or the apartment. We will also review what are called the minutes of the board. Again, assuming that the building allows the minutes to be reviewed, we will review the minutes. These are minutes that are recorded of board meetings, depending on when those board meetings happen. Some buildings it's every month, some buildings it's every quarter, some buildings it's somewhere in between, a few times a year. We'll review those minutes to again make sure that there's nothing unusual in those minutes that affect the operations of the building or the apartment itself. Again, with the reasons why you may want to, clients concerned that there may be a neighbor that's smoking and their smoke is getting into the apartment, or they have a dog that's barking all the time, and seeing whether there have been complaints about that noise. And these are the things that we'll look in the minutes to see if anything like that's reported. We will also look at what's called the purchase application, which is the application that has to be submitted by the purchaser at the time that after the contract is signed, that they have to submit to the board. So we'll look at that to see if there's any unusual aspects or any unusual costs that have to be made by the buyer. We'll look at the alteration agreement, which is the document that presides over any repairs that have to be made in the apartment. So again, some buildings have different nuances on these alteration agreements, that you can only do work for 90 days. And if the work's not done in 90 days, then they have to pay a penalty of $500 a day for each day that it goes over the 90-day period, or there may be substantial alteration costs or deposits that have to be made for that. So again, we'll review the alteration agreement, and we'll also review what's called the sublet application. Again, for some people, that's discerning to them to find out what the sublet rules are and fees. We'll also try to speak to the managing agent just to get a better sense of the building, and we'll gather all that information together. I then send a little memo to the client with my notes on all these different documents and send it to them. And then usually we have a conversation about any of the high points or low points about those documents or notes. And assuming that the client says everything works well for me, then we proceed to go into reviewing the contract. But that's the general part, because there are some clients that after we unearth some information about the building, they say, oh, I didn't realize that the building is going to have a $5 million assessment because they're putting new roof on, or there's going to be facade work, and now every apartment has to pay a proportionate share. Maybe they didn't bargain for that, and they say, well, we're not interested now. We don't want to buy this apartment because we weren't ready for that expense. Well, okay, that's okay, but now we've done our job in telling them what to be aware of in this particular building. So that's part of our job in representing a purchaser.
Mm-hmm. Wow, there's a lot that you do, Larry. I mean, you know, as a purchaser's attorney, a seller's attorney, I mean, you're really looking out for, you know, the buyer's best interest, the seller's best interest, and that's really what I appreciate about you. I mean, you know, you're quick, and you're smart, and you really, you know, are on top of things with clients.
Thank you.
So thank you so much
for
being here. Thank you so much for your expertise. I really appreciate it. And how can buyers or sellers or real estate brokers get in contact with you?
Yeah, so I have you know, I'm available always by telephone. You know, under Chaifetz and Chaifetz LLC, or Lawrence Chaifetz. You know, the phone number's there on the web. We have our own website, a LinkedIn profile, so people can reach out in any of those aspects, and we can put our information on this podcast too, so that people can reach out.
All of the information will be below. Don't fear, it will all be there. So thank you so much. Great. I greatly appreciate it.
Thank you. Thank you.
You've been tuning into Heather Sells NYC with your host, Heather M. Cooper. You can find more episodes on all the major platforms, including YouTube, LinkedIn, Apple Podcasts, Spotify, and on our website, heathersellsnyc.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.